Every day in the USA, people find themselves in court.
Ms. Rawls? We will go on the record in the matter 25 CF 138, State of Wisconsin versus Jennifer Rawls. The state appears through District Attorney Kevin Schmidt in person. Ms. Rawls appears in person with counsel Joel Feliski. We're set today in this matter for a plea and sentencing. Mr. Feliski, do you have a plea questionnaire waiver of rights form?
I do, Your Honor. I can recite the agreement for the record. Ms. Rawls has agreed to plead to count 2 in 25 CF 138. Count 1 will be dismissed and read in. The deferred judgment of conviction as part of this agreement, Your Honor, in 24 CF 169 will remain in effect, meaning the state won't revoke based on conviction here. The parties are agreeing to stipulate to restitution in the amount of $46.36 and are agreeing to a jail sentence of 10 days. I have a completed plea questionnaire with me. May I approach?
Yes, you may. Thank you. Ms. Rawls, is that the agreement that you've reached?
Yes.
Victims' rights compliance?
Yes, Your Honor.
Any victim statements today?
No, Your Honor.
I have in front of me a plea questionnaire waiver of rights form. It does state that you're pleading guilty to count 2, theft of movable property less than $2,500, a Class A misdemeanor. Is that correct, Ms. Rawls?
Yes.
You're 40 years old. You have 12 years of schooling. You can read, write. You understand the English language. No mental illnesses or disorders. No alcohol, medications, or drugs within the last 24 hours.
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the first page of that plea questionnaire. Did your attorney thoroughly go over your rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here that the state would have to prove on or around September 24th, 2025, in Burnett County, Wisconsin, you intentionally took and carried away movable property of Wild Bills without consent and with intent to permanently deprive the owner of possession of that property? Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty is a fine? It could be up to $10,000 or 9 months of incarceration or both.
Yes.
Do you understand that there is an agreement that's been reached and it's been recited on the record, but I'm not bound to follow that agreement?
Yes.
Said differently, I could sentence you all the way up to that maximum possible penalty if I thought it was warranted.
Yes.
Did you go over the criminal complaint with your attorney, and in particular that section called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did take movable property and intended to deprive the owner of that property without their consent?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint along with the statement made by your client to find a factual basis?
So stipulated.
Are you pleading guilty because you are guilty?
Yes.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
And did he look at this matter thoroughly?
Yes.
Did he discuss with you any potential defenses or a lack of defenses you have,
Yes.
and any ramifications as it may relate to that deferred judgment of conviction?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed? As to count 2, theft, movable property, a Class A misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. Count 1 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. We wanted some punishment and conviction on this for two main reasons. One, as the court recalls, Ms. Rawls is on a deferred agreement as well as probation in a previous case where she's working at the Lucky 7 in Webster, where she's, as an employee there, she took a much larger amount of money over time. It would be most accurately characterized as an embezzlement case. Wild Bills knew about this conviction, knew about that, hired Ms. Rawls and gave her a chance. When we had contact with the victim, that's why there was a stronger sense of like a feeling of personal betrayal from the business that we don't normally see in these types of cases, because they felt like they gave her a chance and she threw it back at them. So in this case, that's why there's the jail in it. That's why there's the conviction that would be consecutive to the 44 days that DOC already did initially when this happened, because she was on probation. It was a very similar type offense in terms of like what the victim was, it being another business that she was working at for what she was on supervision for. So even though, you know, someone might say, hey, this is only $46, 54 days of jail is a lot for that. I think given these circumstances and given that she's getting the benefit of not having that deferred judgment revoked, I think that's appropriate. We did consult with the victims related to the Lucky 7 one. They support this. We asked them, I gave them the choice. Do you want me to revoke the DJOC or do you want me to do something different? They chose not to revoke the DJOC because they want to keep getting those payments to get the money back. Thank you.
All right, thank you. All right, Mr. Feliski.
Thank you, Your Honor. Your Honor, we're here today because Ms. Rawls did not make the right decision. In fact, she made a poor decision. She acknowledges that, she accepts that, and she's willing here today to take responsibility for that by entering into custody. As the state mentioned, Your Honor, shortly after this case had initiated, Ms. Rawls, was brought into custody on DGOC for a sanction lasting 44 days. So she's already sat some amount of time and has been punished in ahead of this hearing for this offense. She's willing to take on that additional length of time, Your Honor, because she does understand that this is a very serious matter. There was quite a lot at stake, as the state mentioned. They could have revoked the DJOC here. She could have faced a significantly more punitive sentence from her earlier conviction. In acknowledgement of that, of the poor decision that was made here, that's why she wants to take accountability. This agreement, Your Honor, will allow Ms. Rawls to continue on with probation along with the DGOC. There will be hefty supervision as part of this, so the community will be sufficiently protected going forward. A jail sentence here, as the state referred to, is appropriate given the nature of this offense. While the amount here might be not quite as high as what would typically be brought before the court, it is still serious. It is an amount that was taken unlawfully from the owner of that property without their consent. Allowing the DGOC to remain active, Your Honor, will continue to provide an incentive to Ms. Rawls, along with ongoing supervision from probation to assist in addressing any underlying needs that she may have. In regards to what she has done since this all has occurred, Your Honor, there have been a couple of updates that she's provided to me that I think speak towards her character, the fact that she is taking this seriously and does want to move forward from this. She's continued to pay on her fines and restitution. She has, my understanding, gotten her HSED, has been volunteering her time at the Tribal Center in St. Croix, donating baked goods, participating in community events. One last detail I would mention, Your Honor, in that we are going to be asking for eligibility for ankle monitor, is that Ms. Rawls' son, a Maxwell Knight, unfortunately was recently hospitalized. He's since been released from the mental health facility he was previously staying at. As the primary caregiver and provider for her son, Your Honor, we're simply asking for the ankle monitor to allow her to remain on house arrest and continue providing for her child. Overall, Your Honor, I think the agreement here reached between the parties is appropriate. It addresses the Galleon factors. And I would ask the court to follow it. Thank you.
All right. Ms. Rawls, is there anything that you want to let me know, you want to tell me?
Well, kind of what he said, I do take this serious. I did sit 44 days, so it was my first time ever in jail. I did take that very serious. I do not want to do that again. I'm trying to change my life around. Since then, I have got my HSED. I would actually like to move on and possibly go to college and get some better education that way, not just for me, but for my family. I've been trying to donate, help at the community centers, and trying to go out there in the community and do better and be better. I do believe that everybody gets a chance, and I wake up every day to take that chance and make myself better instead of worse. I've had a lot of stuff go on with my kid. He has been in a mental facility twice now for wanting to commit suicide. As bad as that is, I still keep a positive attitude, helping him. In a sense, it might sound weird, but it's helping me by helping him and makes me want to be a better person. And so I just, I am waking up every day and still just trying to be better with myself. And I do not want to ever be in here for anything again. So I have definitely learned my lesson a hard way, but I have learned it. And that's pretty much all I have to say.
Well, I really am glad to hear that, Ms. Rawls, because your 24 CF 169 case, that was a doozy.
Yes.
That was a whole lot of money, almost $100,000 that you stole. Has she been making her monthly payments?
I did just make a payment before court today too. So it was due today, but yes, I've been making all my payments.
And granted, it's only $500 a month. I would strongly encourage you, even though you're only ordered to do $500 a month, to pay more than that, because whittling that down at $500 a month, I know that the DJOC is open for 14 years, but you really want to have the state hanging over your head for 14 years?
No, I will be trying to make more payments. I've been paying a fine too. So like technically I've been paying like a little over $600 a month right now. So
A fine for what?
it was like court costs and my like DNA and stuff like that. That was like $900 and something too. So that one is actually almost all paid off though.
They must do it separately then, because.
Yes.
Oh, yes.
Yep.
because you're on probation and you're paying that, and then you're paying the state.
Correct.
district attorney that.
Correct. So I pay the DA my restitution and then I pay my fine at the fine place. So,
All right.
and I have been
can
following
confirm I have the
everything.
balance sheet. She has paid every time.
Excellent. That's good.
And I have been following all the rules of like probation and going to my probation meetings, and like I've passed every UA and I'm doing really good there. So.
Well, I'm glad to hear that. And I'm going to tell you, generally, when I'm sentencing somebody and they're already on probation for something, usually it's like, it doesn't make sense to put them on probation again, because you're already having that oversight. But I'm going to tell you, I'm not following the recommendation here. I'm putting you on probation for another year.
Okay.
And it's simply because your 24 CF case, you're set to discharge. Granted, I could extend it there too, but you're set to discharge in August. All right. And if I put you on probation for a year, then it starts today. And then, so it'll be at least until another March. That'll give probation time and you time, because if you're going through the stress of what's going on with your son, that's a lot of mental health burden on you. That's a lot on your shoulders.
It is.
Probation can be used as an asset, as a tool. And I don't know who your agent is, but generally I'm going to tell you, I know them and I like them.
Yeah, it's Leah. I do talk to her about it. Like I've been very open and honest with her about it. Actually, my last probation meeting was just on the 3rd. I walked in there. I mean, I've called her every time because I have had to call the cops on my son. So instantly, I message her right away, let her know, like, I've had police contact, what's going on with my son. When I went in there this last time, I did break down and start crying to her about it, and she says, are you still, like, are you clean? Like, you're not resorting to like drugs or alcohol? And I said, no. I said, I'm still clean. I said, because like drugs and alcohol, that's just putting a Band-Aid on it. Like, it's not going to help my problems or my son's problems. Like, I do know that. So like, I have to be strong, not just for myself, but for him. And I do have other kids too. So, but it's mainly him right now. He's the main focus. Like, I want him to get better. And if I don't better myself and be better for myself, I can't be better for him. And so that is what I'm trying to do. And
Those are all true statements. And I'm glad it sounds like you're having a lot of good self-reflection. I don't know if
Yes.
you're going to therapy.
right now we're trying to set up, I am going to go to some counseling myself just because it is nice to vent with what is going on with my son right now too. I mean, I do have a really good support system, like my boyfriend and my mom, my aunts, my uncles, they're all great support system, but sometimes it's nice to talk to somebody that's not my family, but we're also all doing family counseling together too. So between doing counseling myself, family counseling, and then like Max does have to go to some counseling and stuff himself. I think it will better all of us, and a little counseling and therapy don't ever hurt anybody to get your stuff off your chest. So
It doesn't for anybody and everybody. I strongly encourage counseling, therapy, those
Yes.
types of things. But I hear from a lot of people who are on probation that sometimes they grow a really good relationships with their agent, and their agent sometimes they're not counselors, but the people feel like they are because they're able to tell them all the things, and then you're able to get feedback and you're able to go, okay, well, what are you going to do and how are you going to stay on the straight and narrow and what are you doing?
yes.
And it sounds like you're doing that. And that's why I think with taking into account 24 CF 169 with this new case, having an additional time of probation is not a bad thing.
It probably would hurt. I
Right.
mean, like I said, I totally vented to her, like, and at the end I was like, thank you for listening to me vent, you know? And to be honest, I actually like even told her, and I don't know, maybe I should even thank you. Like, I thanked her for giving me those 44 days. Like, it was very eye-opening, life-changing. Like, I don't ever want to do that again. Like, you will never see me in this courtroom for another crime again. I promise you that. Like, you know, some people might take them 3, 4, 5, 6, 7, 8 different chances. No, I had 2, and like, the 44 days in jail were like the worst 44 days of my life. Like, I miss my kids. I miss Thanksgiving. Like, I've been their guardian. Like, I've never missed any of that. Like, I don't want to put myself through that, nor do I want to put my family through that ever again. So it was definitely a very hard lesson learned, but I learned a very hard lesson.
I'm very glad to hear that. Okay. I am super glad to hear that because you're making the changes. And that's what the justice system is all about.
Right.
To try and get people back on track and to get some help if they need it, and to be able to be law abiding and to think clearly and to be a great member of your community. And it sounds like you're working towards that, and that's great. You're making positive steps. And so, but this does need to be punished.
Right.
But I think the additional probation is good. I'm going to order 10 years of 10 years, no, 10 days, sorry, 10 days of conditional jail. And because I did a 9-month impose and stayed for the 24 CF 169, I'm going to do 9 months impose and stayed with this one because you're going to be on probation. If they're going to revoke you, they're going to probably revoke you on both.
Right.
And so I'm not going to say anything. It's not going to be consecutive because quite honestly, if you're going to be revoked, you're going to be here for a very serious felony. And quite honestly, that's most likely prison.
Yep. And I do not want to go there. So I will not be being revoked. I will do everything I need to do.
So I think with doing what you're doing, this isn't a go to jail now for 9 months. This is you need to have the penalty of 10 days of jail. I am going to give you 20 days to report. Do you have any stance on whether or not the court permits monitor?
No.
Well, you did set 44 days in custody, correct?
Yes, correct.
So I am going to give you the ability to serve the 10 days consecutive jail. And that you don't get credit for that. That's 10 days. You don't get good time for that. That's 10 full days that you have to be on monitor then or sit in the jail. You have to prepay that with Miss Anderson. You have to set it up at least a week in advance. You have 20 days to report. That's house arrest. You can't go anywhere without the court's approval, except for a few places like to work, to doctor's appointments, to probation appointments, those kinds of things. But even if you have to go to a mental health facility for your son, you have to contact Miss Anderson during that time and get permission. Obviously, that one's a big one.
Yes.
But you can't go to a party, you can't go to a friend's house, you can't, do anything like that. It is house arrest.
I fully understand.
And it is a 24/7 monitoring of your sweat. So it'll detect substances and things. So it's a big deal. $443 in fines and fees, $46.36 in restitution. Your bail money should cover that restitution, so it'll just be paying off your other fines and fees. I'm going to say you pay probation that, and not the court. They'll handle that. They'll take care of that. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. I know you've probably already given it. It's probably already in the system, but you still have to go to the jail. They need it. They'll take it. If they don't, they'll say you're good to go and you're on your way. With a case like this, you could request it be expunged through a written letter to the Department of Justice, not to me, but to the Department of Justice. Mr. Flisky can help you, or you can Google that. It's pretty easy to do. If revoked, 2 days of jail. But again, that 2 days doesn't count for your 10 days because that's the punishment portion. Am I missing anything? Do you want no contact with, do they still want no contact?
I would be in the notes.
Let me double check if.
Well,
they
you probably don't want to go to
explicit-
Wild Bill's anyway.
Yeah.
So I'm just going to say no contact with Wild Bill's unless your agent approves. Absolute sobrieties, no use or possession of illegal drugs, substances, paraphernalia, all of the same, quite honestly, let me go to the conditions.
I'd say it's probably the same
It's
conditions.
going to be the same conditions. I'm just going to say I'm incorporating the same conditions from 24 CF 169, then you can just probably cut and paste of what we had for there. And you know them, they'll go over it with you, all of those things. Anything I'm missing, Mr. Flisky?
I don't believe so, Your Honor.
All right. Good luck, Ms. Rawls. And I'm proud of you. You're making good choices and you're changing your life around and thinking better.
Yes.
But don't let all of that stress come down on you. And because as you said, alcohol and drugs, that'll make it worse.
Right.
And that's just self-medicating. That's just feeling numb. So you
Yes.
don't feel.
And that won't help any situation at all. And I do know that, so I don't, and honestly, like I've been doing everything probation's asked and doing good, so keep moving forward.
I am very glad to hear that. All right. Thank you. You can come get your thing for the jail and you're good to go.
I took 100,000 from the Lucky 7 store. Wild Bill gave me a chance, but I wanted just a little more. $46 later, I'm on house arrest blues. 14 years of payments, and I've got nothing left to lose.